Hi everyone, this is Ashley Sloat with Aurora Consulting. Thank you for joining me today for Intellectual Property 101, Part 2. In Part 1 we talked about copyrights, trademarks, and trade secrets, and in Part 2 we will be talking about patents. Again, a little bit about my background. I've been in the advanced sciences or patent strategy space since about 2008 and 2009, and now am the president of Aurora Consulting. We are a patent strategy firm that helps early stage companies formulate and execute their patent strategy, which includes a review of existing applications to formulate how to move forward with a portfolio, drafting applications, prosecuting applications, performing searches, maintaining the portfolio long term, and making sure to match the patent portfolio strategy with the business strategy. If you'd like more information about us, please do visit us at aurorapatents.com. So, as we talked about in part one, intellectual property is all about defining your fence. In real life or in, the more physical world, we define property by a fence. If we have land around our house, we may put a picket fence up. If we have land around livestock or a grazing field, we may put up an electric fence or a fence like the one shown here. So, intellectual property is no different. You use different types of applications or registrations to protect your intellectual property. So, for instance, we talked about copyright to protect works of authorship, trademarks to protect brands and slogans. We talked about trade secret to protect various things that provide a competitive advantage. And then today we will be talking about patents in part two. So, what is protectable by a patent? Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof may obtain a patent. So again, it's a new and useful process, machine, manufacture, or composition of matter, or an improvement of one of these that's protectable by a patent. And there are several different patents, which we will describe here shortly. So the benefits of patenting are they give you the right to exclude others from making, using, offering for sale, or selling the invention in the U.S., or importing the invention into the U.S., or if you were to receive a patent in another country, you could restrict the use or sale or importation of that invention into that country. And the protection lasts 14 to 20 years depending on the filing date and the type, which we will describe. So there are three types of patents that are generally governed by the same novelty and non-obvious guidelines. There are plant patents, design patents, and utility patents. So these are in order of easiest, relatively speaking, to most complex. So plant patents, they protect a plant defined by a set of characteristics determined by its single genetic makeup or genotype. They have to be able to be duplicated through asexual reproduction. It cannot be a tuber, for example, a potato or a Jerusalem artichoke, or a bacteria. Algae and fungus can be protectable by a plant patent. And your fence in this context is the Latin name of the plant, the genus, and the species. So that's again what defines your boundaries of protection. So we just described plant patents. We will now describe design patents. Design patents protect the ornamental appearance of an article of manufacture, not the article itself. The article itself is protected by a utility patent, most likely. So these are the visual characteristics, the surface ornamentation, the configuration or the shape. And the fence in this case are the drawings. These are what define what is protectable and what is not. So for instance, your solid lines in your drawings would be the contours of your protection, and the dashed lines would be those parts of the drawing that are not important or you are not protecting in this application. So lastly, we have utility patent. It protects the way an article of manufacture is used or functions. So, in some cases you can have utility and design working together. You could have a utility to protect the use or the function of an article of manufacture, and then you could have a design patent to protect the way it appears or its appearance. And the fence in a utility patent are the words or the claims, and this is where it's really important to have a skilled agent or attorney help you draft these. And this is one of the things that we do at Aurora for our clients. And in the US and most of the world now, you must be the first inventor to file. The rest of the world is a first to file system. In the US, it's a first inventor to file. So you still must have invented it, but you also must get your invention on file with the Patent Office first. So a nice illustration of this is if inventor A invents and then inventor B invents at some later date, but inventor B rushes to the Patent Office to file an application and inventor A files later than B, B wins because he beat A to the Patent Office. So what this translates to is you need to file early and often. Don't wait to file your patent application. Make sure it gets on file quick so that you can prevent others from beating you there. There's this idea of simultaneous invention, which means that at any given time, there are multiple people inventing the same thing. And so if that's truly the case, that multiple people are inventing the same thing at any one given time, it is very likely that someone may beat you to the patent office. So you definitely want to get there first. The requirements for patentability for plant, design, and utility patents are, useful is only for utility, but novel and not obvious. And that means that for novel, no one publication in the public space can teach all of the parts of your fence. So all of the lines in a design patent, all of the words in your utility or the species and genus, genus and species of your plant patent. And not obvious means that no combination of publications or disclosures in the public space when combined teach every element of your fence. Now, obviously, there's different rules governing this. I mean, you could say that, of course, everything has been disclosed at some point, but there are definitely rules governing this. And that's where, again, a skilled agent or attorney can help you navigate this process. But suffice it to say that the requirements for patentability for plant design and utility applications are they have to be novel and not obvious. So, but there's another question. So we just talked about patentability, right? How do you actually get that registration? How do you secure that piece of paper that says I have a patent? And then the other piece of that is, can you actually practice your invention? And you may say, of course I can practice it because I have my piece of paper that says I received a patent, that it's new and not obvious. But this idea of practicing my invention is actually quite different, related but different. You can think of patentability and freedom to operate as two sides of the same coin. While you may have the ability to patent your idea, you may not have the ability to practice it or the freedom to operate. Conversely, you may have the freedom to operate, but you may not have the ability to patent it. So let's dive into this a little deeper. This is one of the key sources of confusion for a lot of companies and a lot of inventors, so that's why I'm adding it to part 2 today. So patentability, others are excluded from making, using, offering for sale, selling, or importing your invention into the U.S., while freedom to operate is you are not excluded from making, using, selling, or importing your invention into the U.S. That means that somebody else doesn't have a patent that restricts you from practicing yours. So again, patentability, others are excluded, and freedom to operate is you are not excluded from practicing yours. So let's look at that. Let's unpack this a little bit more and look at it in another way. So if you recall, a good patent talk isn't a good patent talk without discussion of a light bulb, inclusion of a light bulb. So the patent invention here is from Edison. We all are very familiar with Edison. He created this beautiful clear glass light bulb. Later, Pipkin came along and created the frosted glass light bulb. So this is a new invention over that of Edison's. So if you look at this a little bit differently, the base invention was Edison's clear glass light bulb, and Pipkin's was this frosted glass light bulb, the improvement. And, they were able to show that this was a novel and not obvious because the clear glass light bulb was exceptionally bright and very hot. So it was very hard for people to even look at the light bulb because it was just so incredibly bright. So Pipkin thought, well, if I somehow frost the glass of the light bulb, it will somewhat dim the light a little bit, but still be bright enough to see, and you can actually look at it and it's not as hot. So that was the improvement that Pipkin patented. So it was patentable because it was an improvement over Edison's. It was new and not obvious. But when you take a top-down approach and look at it from another perspective, Pipkin did not have the freedom to operate. So the fence that Edison got is the green fence, And the fence that Pipkin got was the gray fence. In order for Pipkin to practice his frosted light bulb, he has to pass through the fence of Edison, that green fence. And so, how does Pipkin do this? Because without being able to pass through that green fence, he can't practice his invention. He does not have freedom to operate. He is excluded from practicing his invention. So there are two ways to deal with this in the patent world, or actually multiple ways. Here's some examples. You can either license it, so that means that Pipkin receives a license from Edison, and he says, here, basically, I've licensed the use of your patent. I will give you X amount of money, or I will give you X percentage of profits in order for me to have a key to pass through your green fence. Or Pipkin can say, I will give you a royalty. In order for me to use your patent, I will give you 10 cents of every light bulb that is sold. So that way, Edison doesn't have to necessarily make his light bulb, but he can allow Pipkin to make it, and he gets a small kickback for allowing Pipkin to use his patent. So this is a very brief dive into this whole patentability versus freedom to operate concept, but suffice it to say that when you are looking at your portfolio, you need both of these things. For investors, you need both of these things. To sell your product, ideally, you don't need both of these things, but they're both very important. So you need to have that ability to exclude others, and you need to be able to practice your invention. That means you are not infringing somebody else's patent. You have the freedom to operate. So if you'd like additional patent information, of course, contact us at Aurora Consulting. You can also call the USPTO Contact Center or the Patent Electronic Business Center. So just to summarize both Part 1 and Part 2, there are several IP protection mechanisms. You can do copyright, which is the original artistic or literary work, a trademark, which is a brand for goods and services, a trade secret, which is an invention that you're keeping secret via a company or an individual, and a patent or an invention. So the length of protection for a copyright is the life of the author plus 70 years. Trademark is 10 years and it's renewable after every 10th year. Trade secret, it's indefinite as long as you keep it a secret. And patent is 14 to 20 years depending on type and filing date. So for instance, plant patents and utility are 20 years, design is 14 to 15 years depending on when you filed it. So again, these are the IP governing bodies. You have the Copyright Office and the Library of Congress, the Trade Secret Office controlled by state largely, and the United States Patent and Trademark Office, which has offices in California, Colorado, Michigan, Texas, and Virginia. So how do all of these work together in an effective portfolio? So patents, you can protect the composition, for instance, in this example of proactive. You can protect the trademark, which is the name proactive and how it appears, the appearance of it. And then you can also copyright the infomercials or other marketing materials that you use. And then you might hold the manufacturing methods trade secreted. So thank you. And again, if you have any questions about patents, we'd love to talk to you at Aurora Consulting. Thanks.